Hi there, and welcome back to Let's Talk About Conflict. I'm Lynne Nash, your host, and today we are going to talk all about arbitration. Arbitration is one form of alternative dispute resolution, which, if you don't know what that term is, go back, you'll find a podcast all about it. So today, let's dive in and figure out what is arbitration and how does it work. ADR.org will take you to AAA, AAA, or the American Arbitration Association. Maybe the most common, certainly the most common in the United States. It's highly listed in contracts as the organization a dispute must use to resolve conflict. So it becomes a contractual obligation between the parties. And AAA has their own rules for U.S. domestic and for foreign non-U.S. cases. In that case, when it's a foreign case, it's called the ICDR, International Dispute Center for Dispute Resolution, ICDR, which is also run by AAA. Typically, when you hear a case has gone to arbitration under a clause through a contract, it typically is a commercial type case, business to business or business to consumer, sometimes employer and employee. You are not going to hear about a lot of family law or consumer product cases headed that way because it's very hard to put a contractual obligation to attend arbitration when you buy a product off the shelf at your local five and dime. So with that in mind, I would say the next time you are you're making an agreement with a service company of any kind, buying a cell phone, doing an online app even, read the fine print, because I would be really surprised if you didn't find an arbitration clause. And I want you to pay attention to those, because if you think it doesn't really matter, yes, it does. And you very well could find yourself in arbitration simply because you clicked, yes, I read all of this stuff, which you didn't read because nobody reads it. I sometimes read it, but I don't always read it. And lawyers who say, I always read it, you're like, maybe, maybe not. But bottom line is arbitration is a big part of the legal landscape in the United States, which is all I'm really going to speak to because I don't practice law somewhere else. And I want you to understand what it means to the process of arbitration and what are the ways you might find yourself in one. And then we're going to talk about the process of arbitration itself. That's what today's for. Now, I said AAA, most common, it's what you're going to see in contracts in the United States. But there are also other organizations that provide arbitration services, okay? So FINRA, which means the Financial Industry Regulatory Authority, FINRA also has a very, very well-respected and highly tuned arbitration rules and process. So if you are in the securities market, or you own stocks, or you work with a stockbroker, or you are a stockbroker, or work in the securities industry, you're going to be very familiar with FINRA. And FINRA has an arbitration process. It's just one more of their ADR processes. It's not the only one they utilize either. Also, JAMS, J-A-M-S, provides arbitration services. They have their own rules. And a group called ICCA, International Council for Commercial Arbitration, is known for providing arbitration services specifically around usually cross-border sort of transactions. So it would have to be two countries in dispute. It wouldn't be something all within the United States or all within another country. It's going across borders. So all of that to say, there's multiple ways to do this. Don't shoot the messenger. Arbitration is here to stay, and arbitration can really lend a hand in some interesting ways. Sometimes it gets in the way, in Lynne's opinion, remember gospel according to Lynne, but it's not meant to go away, and it can help move disputes, which is what it's there for, right? ADR, Alternative Dispute Resolutions. So let's circle back and talk a little bit about the AAA, the American leader, says there are 5 general stages of arbitration. Okay. It seems limited, but when we break this down, it'll make sense. The 5 general stages of arbitration per AAA are case initiation, arbitrator invitation, preliminary hearing and information exchange, the hearing itself, and the award. 1, 2, 3, 4, 5. Okay. I would love to tell you arbitration is as simple as you're going to do this and then this and this and it's all going to be done, because it's not. Mainly because lawyers are involved and it's our fault, but also because each one of these stages has some push-pull to them, some give-take, that everybody is going to have to figure out per case, per rule, what makes sense for the dispute that's being brought to AAA. So with that, let's begin with the very first stage, and that is case initiation. So if you find yourself having a dispute with, let's just say, a service provider that you use, your cable company, your internet provider, your cell phone provider, your dealership that you bought a car from. I mean, all of these things, I'm telling you, they have arbitration clauses. So you have a dispute, you don't like the way something, you've tried to resolve it, you're not getting anywhere, you then must take your dispute through the process you agreed to in the contract, that fine print. And that is case initiation. So a letter is sent, forms, to AAA saying, we're going to have to use this service to do this dispute and get it worked out. So a letter is sent, a form is filed, and then a letter is sent notifying all the parties that a case has been filed, that there are dates to respond to this filing, and that there are fees to be collected, some not. That's what happens in this very initial moment, right? So all of a sudden you get a letter that says you're going to arbitration. It's because you wanted to go to court maybe, or you wanted to do this, you wanted to do that, but you contractually agreed to go to arbitration. So I got to tell you, you're probably going to arbitration. Fees in arbitration can be higher than fees in a court of law. Let me say that again. Fees in arbitration can be higher than fees in a court of law. That is not always, but based on the fact that you are paying for the privilege to use AAA's services, you are going to pay at more levels, and the cost is generally higher than if you were in a court of law, because your judge is paid for either with your federal taxes or your state taxes. Okay, so there's just some differences here. But I would be remiss if I did not mention that in employment cases, usually the employer bears the cost of arbitration. And so the employee is not going to be on the hook to pay those fees unless there's something in the contract or it's an agreement in the arbitration itself that if the employer is found to be in the wrong about the dispute, then they would have to pick up their fair share. So like I said, there's give and take around arbitration. There's not just one way to do it. And that's why it's called an alternative dispute resolution process. So from the case initiation, which is the very first stage, you go to the arbitrator invitation. And I got to tell you, the way that word comes out of my mouth, I feel like I'm talking about arbiters all the time, you know, people who actually take care of trees, but that's not what we're talking about. Arbitrators. The invitation goes out. The rules determine, sometimes it's one arbitrator, sometimes there are panels of arbitrators required, 3 to 5 to even more than that. Each one of those are individually paid, just so we're talking about, you know, this ain't cheap. Parties who are in the process can object to an appointed arbitrator. AAA sometimes appoints everybody. Sometimes the contracts allow both parties to choose one, and then the 2 that were selected pick the 3rd. There are all kinds of ways to do this, but if AAA has picked your arbitrator and people object, when the parties object, it's possible that AAA can remove that arbitrator, and then the stage kind of starts all over again. So I want to remind you at this very stage, it matters very much who the arbitrator is, because unlike other forms of ADR, the arbitrator is the ultimate finder of fact and final decision maker. Okay. Other processes we're going to talk about in ADR, that doesn't exist. So the only two I can really think of that this ties off with is court with the judge, that black robe stuff, and here in arbitration with your arbitrator. So it does matter who your arbitrator is, and you need to pay attention to the clauses that you are agreeing to, because you may not know. It gets a little tricky in their strategy and how you make those determinations. Parties don't weigh in on the final decision or resolution. Just the arbitrator's going to make their decision based on what the parties have provided. So that's two. Case initiation and then arbitrator invitation. Once all of that is solidified and you know who your arbitrator is or your panel of arbitrators, then you move forward into the third stage per the AAA, called the preliminary hearing and information exchange. So as soon as you've got your arbitrator or arbitrators appointed and confirmed, a preliminary hearing conference call is going to be scheduled with all the parties, and it's going to be conducted by the arbitrator individually or the panel itself. So in this initial preliminary hearing, the issues are brought forward, things that everybody knows about, and the primary basis for why they're in dispute. And then a choice of rules of evidence, either state or federal, are going to be decided and agreed upon at that stage, so that everybody knows what the rules are regarding evidence. Okay. In procedure. And for those of you who are not attorneys, evidence and procedure are really, really long classes that lawyers take in law school, and that litigators spend a lot of time thinking about, because just because we have information doesn't mean it can come in as evidence. You have rules of evidence that require certain things. And so those things can apply in your arbitration as well. Again, making that very different from, say, a negotiation where you can share whatever information you want to share, but then it's public open forum and, it's disclosed. And I'll tell you now, lawyers like things not disclosed, right? So you've got the preliminary issues addressed. You talk about what the choice of rules of evidence are going to be, and then how the exchange of information, or if this was litigation, you call it discovery. My guess is most people say discovery in arbitration too, but I'm not putting words in people's mouths. And then a scheduling order is going to be put together. And then the hearing date, hopefully, is also going to be set at that time. And so sometimes these initial meetings happen and everybody gets together and they talk about it and talk about what they think is going to take this long. They need this much time to do the discovery or information exchange. And so let's set the hearing date out so everybody knows where this end is coming, and let's work on how we're going to get through this. And let's put together the scheduling order of how the dates these things all have to be done by, because you can't just do this forever. There always has to be a little bit of a finality to it. And that's part of what happens. So after the initial call with all of that, either the arbitrator singularly or the panel, someone will issue the scheduling order, which is really just like court. Court scheduling orders typically are very calculated with certain amount of days for every certain area of discovery and all the different things that are happening. Plenty of motions, practice happens all within the scheduling order, and never go to trial. Plenty of things happen in arbitration the same way. Here are all these things we're going to talk about, but we're going to end up settling this thing before we ever get to the hearing date. And that's part of the point of having these alternative dispute resolution processes, so people have something to guide them and help them make decisions about whether they think they really should keep going with their dispute or try and get rid of it by settling it. So that is sent back out. The scheduling order is sent back out, and it's going to lay out everything that was talked about in the original call and put a date on everything. So at this point, the parties are going to begin to exchange information, use the discovery process just like in a court of law. And just like in a court of law, there are just as many arguments and motions for the arbitrator to make rulings along the way of what information or discovery may or may not be, must be shared with the other party, or is privileged and doesn't have to be shared with the other party, or, process. They want to have a motion about process if they don't think this should be happening the way it's happening, or they think they need more time, and so they're asking for continuances. All of this is very common in a court of law and very common in an arbitration. Difference is, you have a singular judge in a trial court. In an arbitration, you might have 3 individuals who have committed to these dates to get these done and with the hearing. And if you start trying to move all of that around, how are you going to get those 3 individuals' calendars all squared again, not much less all the parties' calendars squared again? So I do think arbitrators take that very seriously, and they try and hold the line about keeping the dates as tight as possible so that everybody is on the same schedule. Kind of interesting. So from there, parties can also move for summary judgment under certain constraints. Summary judgment. In a court of law, if you put in a motion for summary judgment, it says, hey, judge, our facts say law's on our side and we should win. Or, hey, judge, they can't make their case because the law says this, and this is all that they've put forward in information. So we need you to go ahead and say this is a no-go case, and grant this motion for summary judgment. And if there is a summary judgment, that is the end of a case. There is no trial. There's no further. It's the end of the case. That can also happen in arbitration, which is interesting and is probably filed a lot more than people think. A friend of mine who does nothing but arbitration told me that there are some rules around. You can't just submit a motion for summary judgment, or people say in MSJ, you can't just submit it. But does everybody follow the rules? Yeah, I don't know about that either. So it is an interesting process in that so much in arbitration is happening similar to that of a trial court in state, for sure state, and in many ways federal court as well. So once you get through all of these motions and all of the discovery, and the discovery is just the exchange of information, that's just the formal process, that's what lawyers call it, then you're gonna get to the hearing stage. All right, so we've done 1, 2, 3, now we're on 4, the hearing stage. At the hearing stage, this is where the big show happens. Okay, this is like a trial, except it's not as formal. You don't have to show up in a suit coat or suit with your tie and in high heels for the lady. You don't have to do all of that. A lot of people come in and the arbitrator has said, we're going to do this casual, and we're going to do this in person, and here's the location, and everybody comes in, and it's just a little less constraining than the formality of court. And court is formal, and anybody who treats court as informal is missing the point. It's not a place for playing around. So it is kind of nice for some of the parties to be able to come in a little bit more relaxed atmosphere for their hearing stage. I know that these can take place online as well, so I don't want to act like it all happens in person. Some of it's done in some of it is done in an online format rather than being in person. So all the motions are done. The hearing stage per AAA is where the evidence is finalized and presented to the arbitrator or the arbitration panel by the parties and their attorneys. And this can happen in person. It can happen on the phone. It can happen online. And it can even happen just through the submission of documents, which is really interesting to me because in my state, in Texas, you're not going to just submit documents to the court at the trial stage and get something. That's a motion for summary judgment stage, but not once you've reached the trial stage. So that's very interesting and different. But the agreed rules or the arbitration agreement that governs the process can determine how this is going to play out and finalize. And so it can be done multiple different ways. sometimes arbitrators or the panel themselves can request further written arguments be submitted for consideration even after this hearing date, right? And I can understand why, because as the arbitrator, your job is to make the final decision. So if you still had some questions in your mind from one party or both parties, and you wanted to get as much information as you could before you had to make a final decision, that's your last shot. Trial judges don't do that. This is what you put forward in trial, and this is what we do. So that's kind of different too. And again, when I say trial judges, I'm always thinking state. I have very little experience in the federal court system, so I don't want to pretend like I know what I'm doing. I'm not one of those people. But in state court, that wouldn't happen, to be asked for more information at the end of the trial. They make a decision, they make a ruling, they make a verdict, and they move on. So fifth stage per AAA is the award stage. So you finish the hearing, there's been possibly some more information submitted, and there's a date that's on that scheduling order that says we're going to have the award out to you by X. So the arbitrator, once they determine no more evidence is needed, the hearing is completely closed, and the date is put forward when the award is going to be issued. Ultimately, on the date determined, the arbitrator or the panel is going to send a written award to both parties, which delivers the arbitrator's decision of the outcome. Okay, here's why this matters. That is it. That is the end of the process. It is final. Arbitration, unlike all these other forms of dispute resolution, is a binding agreement. There are very rare cases, but I mean, an arbitration can be appealed, but and an appeal just means it's questioned and they've found something that says, hey, you should have to review this again, but it is not very common. Okay, so in the arbitration process, when you get to the end, it's the end. Now you compare that with trial, as I keep saying, this is similar to trial. When you finish a trial, unless you are at the Supreme Court of the United States of America, you ain't done. You don't have to be done. You can appeal it. You can appeal that decision. You can appeal. So there are additional ways to have your case reviewed if you don't like the verdict, the judgment, the final decision from the trier of fact. But that's not really the case in arbitration. So it's a big deal, and you need to pay attention to it. I don't know that you need to be afraid of it, but you need to understand what makes it different and special. And as I said before, I think there are really 5 primary forms of alternative dispute resolution, and this is a big one of them. And it's far more common, I think, than people recognize, because those clauses for we're going to settle this in arbitration are everywhere. So with that, you now have an overview of arbitration. I am in no way saying I know everything and it always works this way. Please don't hear that. But I want you to understand how these processes work. If you want to tell me I'm completely crazy, you know where to find me, and you can do that. It's okay. With that, thanks for joining me, and we'll see you down the road.